Can
May I please, your lordship.
mention so. Yeah, tell me.
Lordship, item number 8, I have instruction to withdraw, your lordship.
You want to withdraw this matter?
Lordship.
But 8 is tied up with 7.
That is a different item, but arising out of from same FIR.
Same FIR.
Lordship.
So 7 will remain.
7 will remain, lordship.
Your good name, please.
A.R. Shom, lordship.
Mr. A.R. Swam, learned counsel for the petitioner, submits that he has instructions to seek withdrawal of this bail petition. Full stop. The prayer is allowed, and the petition is disposed of as withdrawn.
Oblige, your lordship.
However, the connected matter being AB 2936 of 2025 shall remain on board. Remain on board. As on board. As there is no submission regarding the same. We'll take it up when the matter comes.
Oblige, your lordship.
Okay.
Please, Your Lordship, I beg to mention item number 3, Your Lordship. The petitioner has instructed us to withdraw the instant petition. Your
Withdraw.
Yes, Your Lordship.
Same over. You are Mr. H.
A. Chaudhary.
H. Chaudhary, Land Council. Same over. 6 withdraw.
Right.
Okay. Yes, madam.
May it please, Your Lordship?
Yeah.
I would like to appear on behalf of the petitioner, and we have instructions to withdraw the present petition.
Which one?
Item number 7.
Was the 7 also? This part is not like that. Letter part not like same. Your madam is SD. Your good name, please.
D.R. Ahmed.
DR.
Ahmed,
Appearing on behalf of Tarakulla.
petitioner.
With on learned counsel Tarakulla, and 6 submits that she has instructions from the petitioner to withdraw this petition. Done.
Much obliged.
Yes, tell me.
Lordship, I am mentioning item number 12. Kindly adjourn the message for
Yeah.
1 week.
12. In any case, I don't know whether it will be reach or not also. It's an old matter. So next time, do it. Next time we try to do it. Okay. Your Miss Gogoi.
Empathy.
Empathy, learned counsel. 6 an accommodation with regard to the matter. Seeking an adjournment today. The prayer is allowed. It's against conviction, I think. When should I fix it? After it's an old matter. Huh?
1 week.
1 week. Okay. List the matter. Should I fix a date? Old matter. We can fix a date. We can fix a date. So 19. 26 to
Okay.
Number 1.
no, I think they are not ready. I'll have to raise otherwise. Which cases CD have come? This is a motion. That one.
Who scan copy to be
Your sheet submitted.
submitted.
Yeah, so NDPS commercial quantity. Oh, such. Them come. Nobody is there.
Item number 2.
Please, your lordship. This anticipatory bail application is rejected by your lordship, my lord.
Earlier.
After the case diary, my lord.
Yes.
After the case diary, my lord.
Okay. No problem.
Rejected by your lordship, my lord.
I understand. It's fairly submitted by the learned counsel that an earlier bail petition was rejected by this court on
Rejection authorized page
17/12/2025 in AB 2880 of 2025. Full stop. Call for the investigation. We have to see whether it's still continuing. Call for the up-to-date case diary from the Constant Police Station. Murajhar.
Murad.
List the matter on. You can, as you wish.
Can it be earlier?
If you want to do it earlier, then you'll have to do it by VC because I'll be in Aizawl for next weeks. Okay?
Then 11, my lord.
Yeah, okay. You can take it on the day I come back, 11th, 9th.
My lord.
Or if you want to do it earlier, then you have to take it
10th.
VC.
10th.
10th. Okay.
10th. My lord.
10/3.
March.
10th March.
Obliged. For my lord, service has not been complete, my lord.
POCSO,
POCSO, my lord.
scan TCR is
Yes,
available,
yes, TCR is available. my
but
lord.
service report is
Awaited.
awaited with regard to the informant slash respond number 2. The prosecution may take instructions, okay,
My lord.
regarding the said service. Leaves the matter on. This is not a new, this is a new matter, I think.
New matter, my lord.
New matter. It can be in between earlier also.
My lord.
Let it be after instructions, not a problem. You
My lord.
take a chance on after a week or so. huh?
Right.
27. Okay.
My lord. Better, my lord. Obliged.
372.
Item number 5.
They are not ready, I think. 1, 2, Thakil, 5, Thakil. Anybody is there for 6 or something? Case diary has come for the which? Just tell me which cases case diary has come.
In 10 months.
Huh?
Okay.
Others case diary has not come.
Supplementary 16.
No, that will take some time. I think after this bench will have it.
Item number 6.
May I please, your lordship. So report. Earlier
This
of it-
diary or scan copy?
No, lordship, report was called for in this case. It was a non-FIR,
No, actually, interim is there, no?
interim is there,
Non-FIR.
and the petitioner appeared before the
Hmm.
IO.
My lord, report, my lord, on 10/12, we have received, my lord. But that, no any case has been registered against.
So any case. So we can dispose it of at this stage. If there's something, then you can come again. Okay.
Okay, but based on a ZD entry, police has been calling, there is a ZD entry.
Hmm.
Based on that ZD entry, they have neither registered a case till date,
Hmm.
and that is why the interim was extended.
Hmm.
Uh,
You have appeared.
I have appeared.
It's okay.
On 10/12, as per that instruction, my lord, till that time he was not appearing. After
After,
relocation, he was called.
After
for-
that here. After
after
that, you
that,
appeared.
it
After
was-
the interim order, you appeared. So what do you suggest? Should I? Because now at this
Yes.
stage, I think we should dispose it off.
it
If
can-
there is further apprehension, you can come again without a case. Or if it is registered, you can come from it.
as interim was there, it may be,
But,
there is an
but
absolute.
because it will be.
In regards of this ZD only, lordship, in regards of the ZD only, or not in other cases, in regards of the ZDS, there was,
Will that be correct? Hmm? Not be correct? That's what I was thinking.
in regards of ZD
With
number
regard to
13.
GD, I can extend it for some more time, but making it absolute, I have not passed any such order, but I don't know. It may be there also.
Because at that time, that information was
Hmm.
not before the court, man.
No,
I think,
no, lordship, it was there, we have annexed already.
No, I'm not talking about that. On interim was granted on 4/12. We received the instruction on 10/12.
heard DMAD, Land Council and RR Kosher. The petitioner had come before this court invoking 482 BNSS with apprehension of arrest in the context of
ZD
uh,
number 13 only.
in the context of certain allegations made against him, which led to making of GD number 13 of 2000 to the 13 dated 17/8/2025. Stop. He was granted some interim protection and a report was called for. Full stop. Person thereof, comma, report dated 17, the report dated 2/2/2026 has been received.
And that report is dated 10/12.
And no, 10/12. No, this is to the public prosecutor, this report. This is a report 2/2. Oh, it seems so. It should be with you actually. Report deliverable, I'm keeping a copy. Report dated, no case has been registered against the petitioner till now, full stop. It is submit, Mr. Media, learned counsel submits that after grant of interim protection, the petitioner had appeared before the IO. Full stop. And rendered his cooperation. Full stop. Considering the fact that no case has been registered against the petitioner under any non-bailable penal provision, the petition for pre-arrest bail would be non-maintainable at this stage and is accordingly disposed of. In the event of any new facts emerging giving rise to fresh bona fide apprehension, the petitioner would be able to, petitioner would be at liberty to take recourse to the provisions of law. That will do. That will be. Full bench is sitting in the old building,
Full bench, my lord.
in the old building.
Nowadays, Tuesday and Thursday.
We should not say old building, actually. We should say it heritage building. We grew up there only. I have not practiced here.
Yes, and last week, Tuesday, court number 1.
Yes.
May I please your lordship?
This item number 9, charge sheet submitted already.
What was the matter otherwise? Fake currency. Heard, Mr. So-and-so.
It's a my hope, lordship.
And R.R. Koshik, invoking 482. The petitioner is seeking anticipatory bail in connection with Samaguri PS case 166 of 25 under section so and so. This is a subsequent petition. Subsequent
Yes,
petition.
lordship.
Okay. Then we can take the facts from here. So page 17 of para 3. An earlier bail petition was rejected on 30/10/2025 in AB 2461 of 25. Updated case diary was called for. However, Mr. Koshik, learned additional PP submits that in the meantime, investigation has been completed, resulting in a charge sheet. You want to give the number also, white CS number?
Dated 24/10/25.
We can allow, I think, in view of completion of investigation, otherwise. But fake currency case, but that's true. Otherwise, they will submit fresh bail bonds, otherwise. In view of the completion of investigation, despite the nature of the alleged offenses, I'm of the considered view that bail can be allowed at this stage. In such view of the matter, it is directed that in the event of arrest of the petitioner in connection with this case, 50,000 with one surety of the like amount, satisfaction of the arresting authority. Full stop. And subject to the conditions that he shall be available for the trial if one commences, shall not hamper or tamper with events, shall not commit any illegal activities. Okay. Next, the petitioner shall appear before the learned court below and submit fresh bail bonds, upon which necessary orders may be passed by the learned magistrate, learned court bill. Okay, then you submit the fresh bail bonds. And in fact, since you will not be arrested now, you go before the court and submit this bail bond.
Yes, Lord.
Item number 10.
Petition stands disposed of.
May it please the lordship. My lord, this is the 482 anticipatory bail application, my lord. My lord will kindly come to page 12. the FIR.
It's a new petition or
No, my lord, it's
Earlier.
already it was rejected earlier, my lord.
just a minute. It was rejected on 25/11.
Yes. My lord will kindly see the FIR at page 12.
Investigation is not complete, not yet complete. The diary has come.
Diary has come. My lord. In fact, my lord, this is subsequent bail application. There is no new ground. Yes.
Page you wanted to show.
My lord, before going to, my lord will kindly come to page 13.
1-3.
Up to the case that if the last updation is 15/12.
Okay, just let me, you want
My lord will kindly see page 13.
1-3.
These are the, my lord, one, Akhirul Islam, the present petitioner, my lord. His wife, Hasina Khatun. Third, Bilal Sheikh, and fourth, Hasina Khatun. And regarding the others, there are no names. Now, my lord, these all four petitioners, they had previously approached this honorable court at page 18. Which your lordship will kindly see at page 19, the order is there. That is, this is on 24/5/9/2025. Now, your lordship will kindly come to para 4. Kindly come to para 3, my lord. The learned additional public prosecutor for the state has produced the case therein fairly submits that the materials revealed during investigation, there is no involvement of the petitioners. But the other circumstances which have emerged, the matter would require full investigation. Now, my lord, your lordship had graciously considered the bail application of the wife of the petitioner number 1 because she was a lactating mother, my lord. Now, she was given the privilege of pre-arrest bail at page 20.
Okay.
Now, my lord, since there was no incriminating materials with the other petitioners number 2 and 3 and 4, my lord, they again preferred an anticipatory bail application at page 24, which has been registered at 2593/2025. Your lordship's order is at page 25. Now, my lord will kindly see para 4. Para 3 is regarding the other subsequent bail application, other earlier application, and there.
Okay, so these two have been granted bail.
Yes, my lord. But before that, my lord, before making it absolute, your lordship's order is, before making it absolute, your lordship's order at page 19/25/9/25. There your lordship has passed some detailed observations. Para 3. Oh,
This one. Materials did not involve,
yes.
did not reveal involvement.
Then there is no material. Learned PP also fairly submitted, but that has been observed there, my lord. Regarding this person, my lord, there are material. That's why, my lord.
These persons are different.
Yes, my lord.
This is the, out of the 4, my lord, your lordship has considered 3. This
One is
the
left.
one is left.
Akhirul.
My lord, because first of all, my lord, there is no new ground. Secondly, my lord, on that score alone, this petition can be dismissed, my lord, because and other those persons, my lord, that has been fairly submitted, and lordship has also observed it. Against them, there is no, my lord, materials till that time, my lord. So, but this person, my lord, considering the materials that application was
Subsequently,
rejected,
materials have emerged.
from beginning against him, there are materials.
Then this submission is, submission was not, it is partly corrected, means, right? I also recorded it wrongly in a sense, that means. By and large, I submit that materials, there is no involvement of the present petitioners.
May I? Which page number, my lord? Lordship is referring?
19. 19 para 3.
Bottom to the
19 para 3.
para 19.
So Hasina Khatun, Bilal Sheikh, and Asena Khatun are on bail.
Yes, are on this.
Only
Because there are
Akhirul
5
Islam is
proceedings,
left.
only Akhirul Islam is there. My lord, the reason my lord, my learned VP has fairly submitted that the case diary has not been updated. Let it be updated, my lord, your lordship can consider it whether subsequent any materials has emerged.
That can
against it.
always be done.
Because others are since on anticipatory bail, whether they can, their statements can be corroborated.
So far, I have gone through the CD till that time, my lord. From beginning, my lord, against other person, there are
That
no
was
such-
partly wrong.
Yes, my lord.
I mean, I'm not saying, that I also recorded it wrongly. So anyway, that's true. So we'll have to see, in the meantime, the progress of investigation.
My lord,
If investigation is completed, then it can
My
be
lord.
perhaps considered also. It may be.
my lord.
Otherwise, let's see what is the situation, how much materials we have,
Yes.
since that was recorded. Anyway,
It's because
Or-
this FIR is of 8th of June
Right.
25.
that's okay. Good stuff. It was fairly submitted that earlier bail petition was rejected by this court on 25/9, right?
25.
9/2025 in AB 2279 of 2025. They submitted that in the meantime, co-accused Hasina Khatun, Bilal Sheikh and Asena Khatun have been granted bail by this court. Full stop. In this petition, Akirul Islam is seeking anticipatory bail in connection with Mankasar PS case number 87 of 25. Though the case diary has been received, it is submitted by Mr. Kaushik, learned additional PP, that last endorsement is of December. And perhaps it would be prudent to get it updated first. Accordingly, the case diary may be returned back and procured again with the up-to-date status of investigation. Full stop. Oh, and
My lord will not be sitting, I have been told,
in case there's some urgency, I can do it by VC,
my lord.
but I will not be able to see the
Yes,
case diary physically. Oh, it's okay. I mean, if the public prosecutor
my lord.
goes through it and submits,
Yes.
that's enough. That
Right.
is also fine. If it is some cases, it is really necessary.
Take some time because it is from Mankasar.
Otherwise, you take it on 9th or 10th,
But
immediately
my-
after I come back.
My lord, on 9th. My lord, let it be on 12th, my lord, because I will not be out of
As you wish.
station on 9th. 12th,
And nowadays, these things are available. If there's
Yes.
some, you don't have to wait. You
my
can
lord.
do it online.
12 months, 12 months. And deeply.
Finding item 1.
May it please your lordship. Lordship, it is NB.
Not that one, sir. No. Supply, no, your matter is 11. Yours
My
is,
lord, I am 11.
no, it's not, it's a different matter.
Sorry.
You can log out for the moment, okay?
Lordship, FIR page number 15, lordship.
Yes. Charge sheet has been submitted, I was told.
Lordship, earlier also rejected, lordship.
Anyway, let us see. If it is a commercial quantity, we'll have to see 37 again. Let us see this.
Partial, lordship, 21C, 21.
Jay Ghosh,
J Ghosh.
learned counsel for the petitioner and RR Kaushik. It's fairly submitted, but another earlier bill application was rejected on 24/10/2025 in PA 3132 of 2025. So rightly or wrongly, I held in the earlier order that 48 compliance is there. Right. So therefore, we have to go on merits. "37 determination has already been made.
CD may call.
Yes, we can actually, madam,
CD may call.
you would understand. That's okay. We'll call for the scan copy.
Can copy of.
How many witnesses? We can direct, actually, as a matter of policy, all these commercial matters, commercial quantity, we have to speed up because, on the basis of investigation, you would appreciate that on the basis of the investigation materials, if the 37 is against the person, then after charge sheet, it becomes even more difficult.
Yeah.
And after framing of charge, still more difficult.
Still-
So that is the problem. So the only relief we can give perhaps is speedy trial, which is the duty actually, if bail is not possible.
Day of December 25,
Hmm.
3 witnesses were already examined out of 6. So
No.
perhaps
Quite a
one
few.
more or 2 more might have been examined by now.
It is submitted by, how do you know this? You forgot. Oh,
See,
okay.
yes.
Witnesses?
It is submitted by the prosecution uh, on the basis of materials annexed in the bail petition itself, comma, that 6 witnesses are listed in the charge sheet, comma, out of which 3 PWs have already been examined
12 December 25.
till 12/12/2025. You're halfway through, complete. Anyway, but we'll call for the scans.
Yeah.
Call for the scan TCR comprising case diary, charge sheet, depositions and other relevant documents. Fix one. Will 13-2 be okay?
30.
13-3. Okay? 13-3.
Oblige your- Extremely sorry, Your Lordship.
No problem. Go another court plus this.
Second round of litigation, Your Lordship, the petitioner is behind the bar for 219 days, Your Lordship.
I see.
Earlier rejected, the rejection order is in
Pokka
place.
matter.
No, Lordship,
376.
366 2, Your Lordship.
Why then so much time?
Kidnapping, Your Lordship, 366A, page 17, Your Lordship. Sir,
Just a minute, huh? Just a minute.
sir, sheeted.
376 2N is also there.
What is that?
My lord, repeated.
Repeat it.
Repeated.
Lordship, as per my instruction, the victim's statement could not be recorded as she was taking adjournment, Your Lordship. Already surseated matter, Your Lordship, to
Investigate.
19 days.
No, at least the victim.
Victim girl has not been examined.
Yes, Your Lordship, and they are taking adjournment, Your Lordship. As per my instruction. If any condition, the petitioner is,
Should we, because the earlier bail petition was rejected, that was the main ground actually,
yes, Your Lordship.
that she is not examined. So again, that's
There-
position remains the same,
Lordship,
16-12. In the meantime, say 2 months have elapsed.
Lordship.
The offense is repeated rape, my lord.
Hmm.
And for that, at least victim, and my lord,
She's a minor and later he
Not
was found to
minor,
be a married person.
Lordship,
Black.
Lordship, as per my, no POSCO is there, Your Lordship. The guard is major as per my instruction.
Anyway, so
Consensual relationship, Your Lordship, with time. The
we
guard.
can, should we keep it pending for some time? In the meantime, take a report as to whether,
and regarding
Lordship, any condition, Your Lordship.
because otherwise,
219 days, Your
if only the same, because because of the same reason,
Lordship.
it had, instead of rejecting it, we can keep it pending for some time, take an instruction.
No purpose will be served, Your Lordship, by keeping the person in jail, Your Lordship. He has a family to maintain, Your Lordship. It was a consensual relationship. The girl went to his place on his own volition, and he and his family has sent her back. The girl is recovered, Your Lordship. Both her measures,
So I'm looking for new grounds actually. Length of detention, of course, is one,
Lordship.
but this situation remains the same. That is my difficulty.
Lordship, they are tactfully taking time to keep the person in jail, Your Lordship.
That cannot be.
If they wanted justice, they could have
Do you
recorded
have
the
any idea
statement.
how many dates have passed? What is this order? Supreme Court.
The boy is also 28 years old, your lordship.
It's true, but
28 years old boy, your lordship. The girl is also, as per my instruction measure, it was a consensual relationship. She went to his place on her own volition. And when he refused to marry her, then this complaint was lodged, your lordship. And he is in jail for 219 days, your lordship. Search sheet is submitted. No purpose will be served for keeping to keep him in jail, your lordship. And they are tactfully taking time to keep this person inside jail.
no opinion should be expressed, but it's true. Otherwise, I mean, as a matter of policy, perhaps. whether
If they
should be
wanted
kept
justice, they
anyway.
would have recorded her statement, your lordship.
What I'll do is, let us get a report for this. And earlier, as F. Hussain Learned Counsel, 1612, earlier bail petition was rejected on 16/12/2025. At that time, it was observed in the order that though charges have been framed, but the victim girl was not yet examined, full stop. The petitioner is in custody since 16/7/2025 itself, full stop. Any idea how many witnesses in the charge sheet? Stop. Ms. Hussain, Learned Counsel, submits that the victim side has been taking adjournments with regard to her examination, causing delay in her examination and prejudicing the petitioner who is in under trial detention. Full stop.
There are 7 witnesses.
It is submitted by the prosecution that 7 witnesses are listed in the charge sheet. Full stop. While keeping this scanned TCR is available, however, keeping this bail application pending for the moment, comma, this subsequent bail application pending for the moment, comma. A status report is requested from the learned court below, especially with regard to the examination of the prosecutrix/victim. For the purpose of proper adjudication of this bail petition. That I'll do.
That's
So in that they will indicate.
lordship.
In the meantime, the court may examine.
Okay.
So we'll see after that.
Any date fixed? your lordship?
Yes. Sure.
Deeply obliged, your
This is
lordship.
the matter on, you take the date, please. When do you want? Next 2 weeks, I'll be in Oizol. In case you want to do it, you have to do it by VC. Otherwise, after I come back, I'll come back on 9th.
Lordship.
Physically, I'll come back on 9th.
9,
9, 10, 11th. 11th, take it on 11th.
10th, your lordship.
10th, okay.
Deeply obliged, your lordship.
Let's see what happens.
Pending item 16.
There's one supplementary bail. No? Supplementary bail. So the children. Yes, I do. Then,
Then legs in another court.
okay, no problem. Which matter? Supply. We'll take after some time, we'll take it up.
Hearing item 11.
May it please the lordship, my lords, my senior will be arguing.
Online, yes.
Yes.
This was
My
part,
lord.
I'm taking it, okay. So, we can conclude this hearing today, okay?
Yes, my lord. I'm grateful, my lord.
No, no,
Last occasion,
should
last
not-
occasion, my lord, I
Hmm.
have almost completed my argument, my lord.
True.
So, my lord, whether, my lord, I should make again, my lord, the recapitulate the earlier argument, my lord.
Not really, I mean, you can just, I broadly remember.
That the bail application was filed, my lord, by mispresentation. He said that he
That is your main
sent
case.
in main ground, my lord.
Hmm.
According to the accused, my lord, he has submitted his resignation, my lord, which is available, my lord, at page 27 of my petition, my lord. He sent the email to BTPSLR, which is not our email address. Our email address is BTQ. He, my lord, worked for a long time as a manager, so he knew this thing that he was, what is our email? And my lord, if anybody send the email to BTP, what will be the result, my lord? Your lordship may kindly see
It will
in my
bounce.
petition,
Correct email.
in my petition also, my lord, I have demonstrated this thing, my lord, at page 65. If it is BPT SLR was not found in titan.kung.in. Page 65, my lord, your lordship may kindly
Yes.
see.
It will bounce, if the email
Yes, it
ID
will
is not
bounce.
correct.
My lord.
Email IDs are very sensitive, so if it is
Yes.
not exact, it will bounce.
And he projected his case that he has submitted his resignation, and learned court below, my lord, also considered his resignation, and my lord granted bail. Your lordship may another documents, my lord, you have demonstrated that his, my lord, attendance. He is, my lord, he also participate in a press conference where, my lord, he present, and a news clipping was, my lord, published onto this issue, my lord. Your lordship will find at page 48, my lord, news clippings, English rendering, my lord. And, my lord, newspaper, my lord, is available, my lord, at page 50 onwards, my lord. And photograph, my lord, is page 52. Photographs with the news. So him, my lord, committed fraud on court and misrepresented this thing, that he submitted resignation. So my humble, on last occasion, I also demonstrated this thing. And if, my lord, anybody misrepresented, my lord, to the court, what will be the, and procured a bail order, my lord, what will be the consequence, my lord? Onto this issue, I beg to cite two judgments. My lord, last occasion, my lord, I cited this judgment 2024 4 STC, page, my lord, 222,
Okay.
paragraph 11.
Hmm. Right. Paragraph 11.
My lord, D, A, B, C, D, or that bail was procured by misrepresentation or fraud.
Hmm. Right. This is the law on the
Apart
subject.
from this, my lord, apart from this, my lord, a recent judgment, my lord, your lordship, I think your lordship has seen this, that is state of Karnataka versus Darshan.
Hmm.
My lord, on that day, my lord, that judgment was not there. My learned friend, my lord, is remaining in the Gauhati. He will hand over this judgment, my lord. Paragraph, my lord, 22.3.
Okay.
Bail obtained on misrepresentation of, this was on medical ground. Then, my lord, Supreme Court has said that it is also one of the grounds for cancellation.
Misrepresentation.
If anybody obtains the bail by misrepresentation, then my lord, his bail should be cancelled.
Hmm.
And my lord, your lordship may kindly consider the total, my lord, golden ornaments worth rupees 1,34 lakhs and odd. So my lord, if he is not taken into custody, my lord, then my lord, this golden ornaments cannot be recovered.
The bail was granted by this court or no, additional session judge?
No, by my lord, learned session judge, my lord, Silchar.
Never mind. So,
Your lordship will find, my lord, order, my lord, at page, my lord, 62.
okay, I'll see that. So this is one judgment for you, Himanshu Sharma. It's an important judgment.
And my lord, my learned friend may say that whether I have any authority to file this bail application onto this issue, my lord. Last occasion, I cited one judgment, alia 2001, Supreme Court 2023, paragraph, my lord, 13.
2023.
My lord, para 13, my lord, 13.
Para 13. What is that? Oh. Total stranger.
Paragraph 13, my lord, Mr. Lolis, my lord, your lordship, kindly see the right-hand column, middle. This court held that the frame of subsection 2 of section 439 indicates that it is a power conferred on the courts mentioned therein. It was held that there was nothing to indicate that the said power can be exercised only if the state or investigator agency or the public prosecutor moves by the petition. It was held that the power so vested in the High Court can be invoked either by the state or by any aggrieved party. And stretching upon this word, my lord, by any aggrieved party. I am the victim, I am the informant, my lord, so I am the aggrieved party, my lord.
You're the informant.
My lord, I am informant, my lord, and
Yes,
I am one of the, yes.
Informant can move. That is settled. That we have to just see whether what are the materials, whether it is justified. Okay. So locus
Right.
standi, if you're the informant, locus standi, I think it's not a problem. Anyway, so this is one judgment. Vishnu Bardhan is what? What you submitted a judgment called Vishnu Bardhan and Deepak Jadhav.
This is my humble submission, my lord,
Okay, fine.
in nutshell.
Shall we proceed?
My lord. My lord, in this case, whatever my learned friend has submitted, my lord, these are matters of investigation only. Police is still investigating the matter, and
He's saying that the bail order before the learned court below was obtained by misrepresentation.
but my humble submission is that
According to you, it is not misrepresentation. These are matters of investigation.
matter of investigation. Police is still investigating the matter. Until and unless police complete that investigation, they come out with a finding that whatever he has submitted, because there are two issues, my lord. That email ID domain, titan.co.in, that is a private domain, my lord. PTP SLR something @titan.co.in. There is always a difference between the public domain and using the public domain and the private domain, my lord. If somebody uses the public domain, then that email ID cannot be changed or it cannot be curtailed or changed to something else like that, my lord. But if somebody uses a private domain, my lord, then the email ID can be blocked. It can be, the address can be changed, my lord. On that particular day on which 14 June 2024, my lord, on the date on which the mail was sent, whether that email ID was valid or not, that will be available only after the completion of the investigation, my lord. First of all, that has to be looked into, my lord. Because the private domain can be, email address of a private domain can be changed anytime, my lord. Secondly, my lord, the signatures that he's referring to in page 47, my lord, attendance signature, my lord, that he has signed on those attendance register at page 46 and 47. His name is written in number 1, my lord.
Page 46.
There's a monthly attendance register, my lord. Some initials are there.
Attendance register.
My lord, or somebody else has signed.
What was his name? Pannapal.
He was working in that organization, my lord.
Oh.
My
Manna-
instruction is that he has resigned on 14/6, and thereafter he is not attending their organization, my lord.
14/6?
14/6/2024, my lord. The incident happened on August, my lord, 7th or 8th of August. And the Lord learned court below, while granting the bill, has rightly said that unless these are proven, my lord, that signature, that initial has been done by him, it cannot be at this stage, it cannot be said that he has done that purposefully, my lord.
Investigation is still going on? Okay, not charged.
Moreover, my lord, the two he has also submitted two salary slips, my lord. That is available at page 43 and 44, my lord.
Just to. Yes.
Manufactured by the organization, my lord. Neither the employer's signature is there that he has received that salary for that particular month, for the month of June and July. These are the salary slip for first one is of June 24, the second one is of July 24, my lord. The employer's signature is there, nor the employee signature is also there, my lord. Nor anywhere it is written that the amount has been credited into his bank account, nor they have annexed the account number in which the amount has been transferred, my lord. This can be manufactured by anybody, my lord. These are matters of investigation only, my lord. While granting bail, my lord, certain conditions were imposed upon the accused, my lord. And he has neither, there is no allegation that he has violated any of the conditions, my lord. If he has violated any of the conditions, if they are not satisfied with the investigation, they can very well go, they can produce all those documents before the IO, my lord. Until and unless the IO comes to a finding that those things were, or he has signed those documents, or that email ID in which he has sent a resignation letter, that was a false one. It is not the email ID of the company. That will be a different aspect, my lord. Otherwise, whether at this stage this revisional court will look into all those evidence, my lord.
Criminal petition. Anyway.
But in reply, I want back to draw your lordship's kind attention to one document. Page 43. Your lordship may kindly see what is the email ID. My learned friend said that, yes, I have manipulated the email ID. Here also your lordship will find BTQ.
43.
My lord, page 43 and 44,
BTQ, yes.
BTQ. And my lord, another aspect, my lord, of this matter is in my this petition, my lord, cancellation petition, we have categorically stated that our email is BTQ, not BTP, which was he sent, it is jumped. But my lord, if onto this to water down my submission, my lord, he could have produced the status report of his resignation, which he has sent. Why he has concealed it? Could have produced that, yes, I have sent mail and it was delivered. Another aspect, my lord, my learned friend said that, yes, there is no signature, my lord, it is copy, my lord, from the copy, so there is no signature. He can produce his bank statement also, whether this amount has been credited or not. Why he has not submit any document onto these issues? And it cannot be a matter of investigation, my lord. Because investigating authority will see that whether this property was stolen or not. And whether he has committed an offense or not. Onto these issues, there is no complaint and police has no jurisdiction to investigate this thing also. They can investigate, my lord, if you lordship directs the police that yes, investigate this thing. And if you found guilty, then you can book this person also for another case.
No. Okay, I'll look into it.
Deeply obliged, my lord.
I'll
Grateful,
look-
my lord.
I'm reserving it. I'll look into it carefully.
My lord.
CD,
Deeply obliged.
oh, can I keep the CD? But I cannot keep it for long. Yes, CD will be required.
I have not followed the arguments earlier, but then going by his statement, my lord, the month of August, he was there.
He was there. Anyway, I'll have to see. Step down. But it will be difficult to carry the CD, you know. I'll try to do it today only, but I have some time constraint also to do. It'll not be, huh?
Luminous otherwise.
Not voluminous.
For the case
Is
of Mark.
it safe to carry, but we are carrying case records. But I don't want to hold up the CD also or to, even if I pass the order in a week, suppose, then CD has to be sent back again by messenger. It will take some time. I don't want to hold it up. Let's see what I can, if I can. You place it. CD will be necessary. Without CD, it will be difficult. That's all. You
Deeply
can log
obliged.
out. You can please log out. No problem. Other hearing matters, what should we do? Adjust it on.
As I am told, my lord, there it might not take that time.
Hmm.
Because if that.
Mr. Ganguly, which matter you have?
I'm waiting for item number 14. Let it come after 2 or 3 weeks, Lord. Item 15, Lord.
Yes, yes. We're not part heard, no? Not part heard.
No.
No. After 2 weeks? I don't know. After 2 weeks.
Item 15. Interim is there, that will continue.
Interim shall continue. After, shall we fix a date or leave it to the registry?
Leave it to the race.
On a date to be fixed by the registry,
Let it then come up after 3 weeks.
after 3 weeks.
Public.
You have anything to say? Oh, just a minute, Mr. Ganguly, just a minute. He was saying that we'll adjust it today. Because I have a division bench also, because I'm going tomorrow to Bhopal actually, so
After
some
3
things to fold up. Since both of you are here, you can also suggest a date if you want. On which date, as of now, we have said after 3 weeks on a date to be fixed by
It
registry.
will remain like that. Lord. His name may also be recorded.
Yes,
He is for the
as
real
does
account.
learned addition, amicus. For the informant. These two are 2020.
Single them break right now.
We'll just keep it for some time. Passing application. We can fix this after 1 week also. Your matter, your matter. Should I fix it after 1 week? List the matter after a week. Shall we leave it to the registry on a date to be fixed by registry?
But the problem will be because your lordship will not be here.
Uh,
These all cases, TCR is there.
Which cases?
14, 15 deciding matters, my lord. TCR is there because
Okay.
your lordship might want to go through or might want to.
No, this can be heard by others also. These are not part heard. These are not heard.
These are not part.
These are all new matters, not part heard. Okay. 14 minutes. I have to go also in any case. 14. Who, anybody appearing for 14? Huh? You are the amicus? Acha, oh yes, yes. For caution? Yes. After 2 weeks, on a date to be fixed by registry. Registry? Yeah, 16 will hear. Yeah. Briefly we'll hear in second half. Your DB is also there now.
May I please your lordship? Lordship, in this case, my lord, I file an additional affidavit, my lord. My first point is that, my lord. Your lordship, kindly look to the 56, page number 56 was started. Yes, my lord. Additional affidavit I filed there, yes, because Article 22, subsection 2 has said, if a person has been detained and his was not produced before the, my lord, magistrate within 24 hours, excluding the journey time, then his right under Article 22, subsection 2 has been violated. I want to show something, my lord.
Investigation, to my knowledge, is not over, lordship.
Over, my lord,
Is it?
charge sheet has been filed. I have annexed the
I'm
charge sheet.
sorry, sir, lordship.
I have annexed the charge sheet, my lord. In my lord, last affidavit. Yes, yes, my lord. Yes, my lord.
Lordship. Yes, yes. Yes, yes. To assess what are the materials. Yes. Yes, yes. Yes.
Yes,
Yes.
my lord. Yes, my lord. Article 22, subsection 2. Yes, my lord. Your lordship, kindly look to that, my lord. Page, my lord, first, my lord, para 66 page, my lord, para 4. That on dated 11/7, have a look at para 4. 11/7 to another office order so and so was issued, and Rahul so and so and sub-inspector Gauhati was detailed the investigation in the case narcotic drugs psychotic substance. In the instance they fight the said office order, Rahul sub-inspector was directed to submit page 66. So sorry, my para 4, page 66. That is not a para 5 is important, my lord. Para 5. Your lordship directly come to the para 5. Yes, yes, sir. My lord, your lordship kindly come to the para 5 of the that charge sheet. This is the charge sheet, my lord. Final complaint, final. Yes, my lord, final complaint, file against the petition. Para 5, have your lordship got it? Yes, my lord. Complaint under 36A, para 5. Inner page 5, bottom part that was written. That in pursuance of the office order number so and so dated 11 sub-inspector so and so zonal unit, but he mentioned the said office order departed from the office, arrived at Gauhati railway station on 11/7/2025 around 10:10 p.m. After arriving the aforesaid location, Sri Abhishek Kumar, Sub-Inspector General Public, requested them to be present as an witness during the search recovery of the seizure methamphetamine tablet, which was suspected to be trafficked by Tahir Hussain, Laskar, Arman Hussain, and Arif Ali in Kanchanjunga Express 10 number so and so. If your lordship go to the seizure list, it was recovered from my lord Tahir Hussain, not from these two petitioners. I represent my lord. Yes, my lord. Yes, my lord. It was recovered from Tahir Hussain, my lord. Then, my lord, in reply, none of them accepted his request. They cited domestic reason, also said they are a passenger, therefore cannot stay with NCB IW. Thereafter, Sri Abhishek Kumar Sub-Inspector so-and-so, RPF, Gauhati approached A.B. Khan Sub-Inspector RPF after sharing the above mention regarding the methamphetamine tablet, requested him to provide NCB official to independent. The duty of the officer provided Mr. Ahmed as constable and Sri Ramshankar Pawar, RPF and Timi Andebe independent witness. And my lord, para 7. Then your lordship come to the para 7. That as per information of Abhishek Kumar along with NCB team and the two independent witnesses searched on platform number 3 at about 10:40 p.m. found that one person whose appearance was matching with his information, wearing brownish color half shirt, gray color jeans, black color cap, and white slippers, was sitting on waiting chair on platform number 3 of Gauhati railway station. That person carrying one dark color bag. Abhishek Kumar, along with NCB team, two independent witnesses approached him, showed his service identity card to him, introduced his both independent witnesses asked to introduce him, to which he discussed himself as Tahir Hussain Laskar, aged about 22 years, so-and-so, Kasar. During voluntary statement of Tahir Hussain, Laskar revealed that he was deboarded train as per direction of Arman Hussain and Arif Ali, both the petitioner. Due to regular checking was undergone to train. Then thereafter, Abhishek Kumar Sub-Inspector shared his information with Tahir Hussain. Laskar said he, along with Arman Hussain, Arif Hussain, were trafficking huge quantity of methamphetamine tablet. See Abhishek Kumar Sub-Inspector Tahir Hussain Laskar about luggage that he was carrying. Tahir Hussain showed one dark bag which he was carrying. In the Abhishek Kumar asked him to open the bag. Tahir Hussain opened the dark gray bag and took out from it presence of individual. The dark color bag, electrophoto identity card, that is one thing, recovered, were covered with bluish color plastic. The said cardboard box was found packed with brown color. When asked about the content of the said box, Tahir Hussain Laskar replied it contained methamphetamine tablet. The box was opened. Inside the many black color Ziploc plastic pouches were found. One of the pouches opened, it contained mostly orange color, some green color methamphetamine. On preliminary question about methamphetamine tablet, Tahir Hussain Laskar revealed that Arman Hussain, Arif Ali also receiver of the methamphetamine tablet. That thereafter they asked Tahir Hussain where about the Arman Hussain, Arif Ali, replied that Arman Hussain, Arif Ali are Kanchanjunga Express, train number so-and-so, which was at the time of station, platform number 3, Gauhati Railway. He said that does not know the seat number and coach number of Arman Hussain, Arif Ali. However, said the full name and this Arman Hussain is Arman Hussain, so-and-so, with my full name address. Then you will also come, my lord. And sub-inspector inquired about the appearance of Arman Hussain Arif Ali. Tahir Hussain also informed that Arman Hussain Arif 22 years wearing pink round neck, t-shirt, grey color bag. Arif Ali 22 years wearing red color t-shirt. That thereafter Sri Abhishek Kumar so-and-so in the name of Arman Hussain and Arif Ali, after explaining their appearance, requesting to do Pankaj Kumar so-and-so. Now, important thing is Kamal. Director to identify Arman Hussain Arif Ali to serve the notice at around 10:50 a.m. Sri Pankaj Kumar Suhan and so Sipoy boarded at Kanchanjunga, where Rupesh Kumar driver instructed to proceed official vehicle in touch. Kanchanjunga, the said train left station around 3 p.m. Thereafter, identifying the person Arman Hussain and Arif Ali said notice 67 notice served to the suspected Arman Hussain, directed to appear before the investigating officer. Thereafter, locked the pouches which will be found box in the Tahir Hussain. My humble submission before your lordship is that, my lord, on that day, 11/7/2000, Kanchanjunga train has been left. I was detained by this person, my lord, a police person, Arman Hussain Arif Ali. If that is so, my lord, and Caesar list state 00.15, search comes Caesar at 12. I shall be produced, my lord, on my lord, 12, my lord. But I was produced 13, my lord, evening before the police. That yes, yes. 25, my lord. Yes, my lord. 24 are detained, my lord. They are produced on 13, my lord. In the evening, my lord. That is my case, my lord. No, that is one of the point, my lord. Because the contention, my lord. Yes, my lord. There is no recovery from this person. These 3 persons, the allegation against them is that these 3 persons together come in Kanchanjunga space. One was, my lord, detained. Yes, my lord. Then they said, on the basis of his statement, both 2 persons were arrested. That is the story of the, my lord, final complaint, my lord. That is on the basis of the statement. The main thing is that Article 22, subsection 2 has been clearly violated. And my lord, if your lordship satisfied on this point, I want to submit some judgment of our High Court, my lord, as well as one Apex Court, my lord. In this case, what happened, my lord, he is appearing from the other side. I am appearing this side. And this is the only case of the High Court, my lord, where accused was took to the, my lord, High Court, and Honorable High Court said arrest is illegal. So he is a free man. He can go walk out from the court as a free man, my lord. Did they? তুমি গম পাইছা না অমল দত্ত যে তুমি অৰুণাচলত আছিলা মই যে আপুনি সেইটো কেছৰ কথা কৈছে 2015 1 GLT 517, man. Your lordship, kindly come to the, my lord. Para, my lord. It was not like para, my lord. Page number, my lord, 520, my lord. Your lordship, come to the. Yeah, my lord. Article 22, right hand side, my lord, has. I can read whole the judgment, my lord, but I am not reading. I am the main part. Article 22 of the Constitution of India deal with the protection against arrest of detention. While clause 1 and 2 deal with the arrest, second part of Article 22 deal with the preventive detention, which present case is not concerned. Clause 1 provide that no person who is arrested shall be determined custody within inform as soon as may be ground of such or shall be denied any right to the consul to defend by legal petition of his choice. Clause 20 which provide every person who was arrested, detained, custody shall be produced before nearest magistrate within 24 hours such arrest, excluding the time necessary for the journey from the place of arrest to the court. That is important, my lord. I was arrested in railway station, my lord, Gauhati railway station. And CGM court, my lord. To the court magistrate, and no such person shall be detained, custody. The word has been used, detained, my lord. But said period without authority of magistrate. The language of clause to make it abundantly clear, the requirement under said clause is a mandatory non-compliance of which arrest is unconstitutional. Clause to make it clear that no person who is arrested shall be detained in custody beyond 24 hours without any authority of magistrate. In this case, Alupia did not produce so and so facts, and he was straightway brought Alupias and produced after 2 days. But my case, 852 is illegal, unconstitutional. Secondary point is that then one judgment, Uday-san, has been discussed, my lord. In Uday-san versus Abdullah, the applicant deprecated the practice of withholding the information of the court about the requirement arrest accused to the, it was held that after a bail, it should be granted, my lord. Then your lordship have the next paragraph, my lord. Having regard to the above, the court is of view that accused Sri Tapan Datta should now be released as his continuous detention has become clearly untenable. As noticed, he has been granted bail by this court in 4 cases that has been mentioned, my lord. Since a finding has been recorded that Sri Tapan Datta arrest is illegal, among the violation of Article 21, 22 Constitution of India, question of compensation may have to come. List on so and so, so and so. Accordingly, Sri Tapan Datta can now walk out from this court as a free man. Register. Yes. And my lord, the constitutional mandate is also there. Constitutional mandate. My lord. Yes, my lord. Yes, my lord. Yes, my lord. Yes, my lord. That is important, my lord. And in the Caesar list, they said 0015 on 22. Caesar list, they have mentioned that, my lord. I was detained as per it was arrest. When the train has been left, before that, I was, my lord, detained. 11 a.m., 11 p.m., train has been, my lord, left. 11:07. So, if that is so, my lord, I shall be produced before the court, my lord, within 24 hours. That is the constitutional mandate. I was detained by the journey time is from the, my lord. Yes. Yes, my lord. Only thing is, my lord, railway station and CGM. That is the law, my lord. 11:07. Yes, my lord. 12:07, 11 p.m. And I was produced on 13th. May I read argue other point, my lord? Yes, my lord. My lord, my humble submission before your lordship is another judgment. To that point, my lord, there is another judgment of the apex court. I first clarify this point, my lord. Recently passed this judgment. Same footing, my lord. Two children. Para 4, paragraph 10, impugned judgment, the High Court has recorded the factual finding. Read from the document, it is crystal clear the applicant has detained, taken in custody at 6 p.m. So mentioned, my lord. The submission of learned counsel appearing for the appellant is the person to the lookout circular is against the he was detained airport 11 hours 5 p.m. but he was shown arrest 1:15 hours at 6 March. Same thing has been done in my case, my lord. I was arrested, shown arrest later on. I was detained earlier, my lord, by the appellant enforcement director and was produced before magistrate within 24/11 hour on 6 March 2022. This is the argument of the defense side, madam. And what is the matter? Then my lord, facts has been mentioned. May I read, my lord? Para 6, my lord. This argument cannot be accepted Admittedly, LOC was issued at the instant of the appellant, Director of Enforcement by executing LOC in limitation detained yesterday, IGI Airport 4 March. On the appellant, the finding fact recorded paragraph 8 is that indisputably physical custody respondent was taken over appellant from the Bureau 11 hours 5 March 2002. Thereafter 11 hours 6 March 2009 an arrest memo was prepared ED Raipur. He was produced before the court 3 p.m. 6:30 2024. The perusal of arrest underscores that type order was kept ready. The date and time of arrest was kept blank, which appear finally filled by hand. Admittedly, the respondent was not produced before the nearest magistrate within 24 hours from 11 a.m. on 5 March 22 from the IGI airport. That is important. Therefore, the arrest of respondent rendered completely illegal. As a result, there is a violation of clause 22, article 22 of the Constitution. Thus, in continuation of this respondent in custody without producing him before the nearest magistrate within stipulated time of 20 is completely illegal, and if infringing fundamental right under clause 2 of article 22 Constitution of India. Therefore, his arrest get vitiated on complete 24 hours in custody, since there is a violation of article 22 to Constitution, even this fundamental right to liberty. The requirement of clause 22 article has been incorporated section 50 Code of Criminal Procedure Code. There is no inconsistency between the provision of PML CRPC, hence by virtue of section 65 PML apply to the proceeding PML. Once a court, while dealing with the bail application, find that fundamental rights of the accused under article 21, 22 of the Constitution of India have been violated while arresting the accused or after arresting him, it is duty of the court dealing with the bail application to release the accused on bail. The reason that arrest in which stand vitiated, it is the duty of every court to uphold the fundamental right granted article 21, 22 Constitution of India. Therefore, when arrest is illegal and vitiated, bail cannot be denied ground for non-fulfillment of twin tests under clause 2(1) of section 47. Hence, there is no either impugnment order. Accordingly, the appeal is dismissed. I was released on bail. Appeal file dismissed. Then I come, my lord, in respect of ODS. Then may I submit, my lord? Then your lordship come to the page 39. In respect of 48, they have given an intimation of arrest, my lord. 12/7 to the after arrest of his telephone talk to his, yes, my lord. After his 12/7, after his arrest, he was telephonically talk his elder brother, namely Arif Hussain. His mobile number is so and so, and intimated about his detail of his arrest, seizure 8.821 methamphetamine tablet. It was intimated on 12/7/2025, but no ground of arrest was given to the petitioner as per Bihan Kumar second judgment. And I want to submit one thing, my lord. Lordship, kindly come another affidavit file, I page 54. Yes, my lord. Yes. Page 52, 7 to the about arrest, intimation of arrest under section 48. On dated so and so, his platform number so and so, Tahir Hussain, thereafter Arman Hussain was arrested in connection with this connection, so and so, in this you are informed, some of has arrested on so and so under section 42 for HC. This is namely Arman Hussain will be produced before the court and magistrate Gauhati at Assam. Then you will also come last part, my lord. Although, my lord, in record, my lord, it was come on blank, my lord, because I think, my lord, I do not, I cannot sure, my lord, it was given after the production of the accused person. That is received at court premises Arif Hussain, brother-in-law of Assam. My humble submission before, this is not the ground of arrest. 1 point, it is only an intimation of arrest, because it was not mentioned, my lord, that why, what is my role in that particular thing, my lord? And second thing is that, my lord, it was given, it is clearly violated, my lord, what, my lord, law prescribed in Pankaj Bansal case. At the time of production, if any document has been given, my lord, that is, my lord, cannot be considered. Pankaj Bansal, paragraph 43. If your lordship go to the Pankaj Bansal case, paragraph 43, my lord, that will be clear. It should be given, my lord, as per new judgment of me Rajesh Shah, it should be given 2 hours before the production, my lord. And Pankaj Bansal has categorically stated, my lord, that judgment. Understand? That is my submission, my lord. And ground of arrest or facts, my lord, they on the basis of 67 statements, so and so has stated that was not mentioned in the 48 notice, because it was produced on next day, my lord. If immediately given, that is different aspect of the matter. It was produced on next day. But it was given on 13, at least they should mention on the basis of his statement. Your lordship, one judgment has been passed, my lord. Apart from the statement, my lord, yes, my lord, yes, my lord. Yes, my lord. Your lordship will find a court asset, allegation against so and so. Happen, no? Yes, my lord. My lord, there are some UPI transaction has been shown, my lord, page 46, my lord. Last part. Search it. Your lordship look to the bottom part, my lord. Yes, my lord. UPI transaction, Arman Hussain and Arif Ali, my lord. All are Arif Ali. Both the accused person. 46, bottom part, my lord, page number. Yes, my lord, additional affidavit, my lord. Search it, I have annexed, my lord, last additional affidavit. Bottom part, 46, 66, 46, my lord. Bottom part. Page 46, bottom part, my lord. I am inner page, page 46. Have you also got it? Yes, my lord. Arif Ali. Yes, my lord.
That is, Worship, running page 107.
Page number. Yes, my lord. Yes, my lord. Yes, my lord. UPI transaction not with my lord. Yes, Arif is co-accused, my lord. I am appearing 1 and 2, my lord. both petitioner. Not with this person, my lord. Yes, my lord. Yes, my lord. Then, my lord. Tahir Hussain, my lord. Transaction took place. Yes, my lord. Then role and evidence, Tahir Hussain, answer accused Tahir Hussain Lashkar intercepted team NCB Gauhati 1.1 method tablet. Involuntary statement of Tahir Hussain Lashkar admitted his guilt. 0.81 kg tablet for monetary benefit, also reveal his mobile phone number so and so, so and so. CF mobile phone number Tahir Hussain Lashkar so and so found in the name of so and so, so and so. Amuk tiyahi to kya puri asan. My logic kindly to be. One important mile, this statement, they have stated that when we take this person, Arman Tahir Hussain Lashkar, on the basis of his statement, we were arrested, my lord. But that was not in the, my lord, 48 notice, because it was given on 13. The role of evidence B2 kiman page rase? Page number 112. Page number 109. Role of evidence accused Arman Hussain. In voluntary statement, Arman Hussain admitted his guilt for trafficking his contraband 8.21. CM mobile number is found in the name of Arman Hussain. CDR and Talaga analysis mobile phone of Arman Hussain. From CDR of mobile phone number Arman Hussain was contact with Tahir Hussain 22 times. Tahir Hussain Lashkar mobile phone Raju Hussain so. During a bank account, Arman Hussain, Punjab National Bank, huge transaction, Arman Hussain, Arif Ali as between Arman Hussain and Raju is detected. Raju Hussain is not accused in this case, my lord. The detail above has already been mentioned in paragraph 54 of the transaction presented. This is the allegation, my lord. Only, I think, my lord, a phone call with, yes, let's follow that. Tahir Hussain, nothing is available, my lord. Arif Hussain, okay. Duta. Arif That is, my lord. And my lord, I want to, that is telephone intimation of arrest, I have said, my lord. 47 also, my lord, that cannot be said, my lord, because basic fact is not available. One important thing is that, my lord, in respect of memorandum of arrest, page 38. Page 38, my lord, memorandum of arrest, signature of witness, Sandeep. The law said it is either family member or respectable person of that locality, my lord. But as per my information, this Sandeep is a police officer, man. And he cannot be, my lord, respected, cannot be taken as a respected person of this way. There is a judgment of our High Court, my lord. You cannot take a police officer as a respected. Anyway, the law is that statement made before the police officer is not evidentiary failure. The law is that you take the respectable person. This is not the respectable person, Sandeep. That is my submission, my lord. And in respect of 47 also, my lord, same my prayer, my lord. 47 also not this case, that on the basis of statement so and so, that you are arrested in connection with this case, my lord. And it was produced on 12/7, my lord. They have to time, my lord, to produce all this evidence. That was not done in the instant case. I want to produce some judgment, my lord, of course, my lord. Yes, my lord. That is why I am. Yes, my lord.
Your lordship can again.
Yes, my lord. Yes, my lord. Yes, my lord. Yes, my lord. Yes. Yes, my lord. Because, my lord, earlier this was not argued before your lordship, my lord. Yes, my lord. Yes, my lord. Could you watch? Yes, yes. I'll take your lordship to the. Yes, yes. I'll take your lordship to the charge sheet file that starts at page 62. In the additional affidavit. Uh, Let me start with lordship from paragraph 10. My friend has read out a few paragraphs that your lordship will find at page 68. 68. I'm just reading out, lordship. That thereafter, Sri Abhishek Kumar, sub-inspector, asked Tahir Hussain Laskar about the whereabouts of Arman Hussain and Arif Ali. Tahir Hussain replied that Arman Hussain and Arif Ali are in Kanchenjunga Express, train number so and so, which at that time was stationed in platform number 3 of Gauhati railway station. He said that he does not know the seat number and coach number of Arman Hussain and Arif Ali. However, he said that the full name and address of Arman Hussain is Arman Hussain so and so, and full name of Arif Ali is Arif Ali so and so. When Sri Abhishek Kumar, sub-inspector, inquired about the appearance of Arman Hussain and Arif Ali, Tahir Hussain Laskar informed that Arman Hussain was aged around 22 years and wearing so and so. Next paragraph. Therefore, Sri Abhishek Kumar, sub-inspector, prepared 2 notices under section 67C NDPS Act in the names of Arman Hussain and Arif Ali, and after explaining their appearances, requested his team members, namely Pankaj Kumar Chauhan, Inspector, Sri Sanjit Kumar, Inspector, Sri Aniket Yadav, so and so, driver, to identify Arman Hussain and Arif Ali and serve the said notices to them at around 10:55. Pankaj Kumar Chauhan, Inspector, so and so, all those boarded Kanchenjunga Express, whereas Sri Rupesh Kumar, driver, was instructed to proceed in official vehicle and be in touch with NCB officials in Kanchenjunga Express. The said train left the station at around 11 p.m. Now, they board the train at 10:55 and this train leaves the station at 11 p.m. Thereafter, identifying the persons, namely Arman Hussain and Arif Ali, and the said notices under section 67 were served to the suspected persons, Arman Hussain and Arif Ali, with direction to appear before the investigating officer. Thereafter, lordship, this routine work, I will take your lordship. This is a seizing part. Then I will take your lordship to paragraph 17 at page 70. I'm not taking your lordship to all those details of seizing, that would not be necessary for the purpose of bail. Paragraph 17. The videography of the search and seizure procedure in this case was done, paragraph 17, at page 70. That the videography of the search and seizure proceeding in this case was done by Rajneesh Kumar Hawaldar using a Samsung Galaxy phone. Search cum seizure list was prepared. Seizure proceeding was completed on 12/7/2025 at around 0015 hours, that is 12:15, in the presence of Tahir Hussain Laskar NCP team and both the independent witnesses. The search cum seizure process was completed with us 18 lordship can leave. 19. Thereafter, Abhishek Kumar, Inspector, served notices under section 67C of the NDPS Act to Tahir Hussain and both the independent witnesses, whereby they were directed to appear before Rahul Kumar, SI NCB Gauhati, for recording their voluntary statement. Now, after recording their voluntary statement, I will take your lordship to paragraph 23 onwards now, at page 73. The voluntary statements of accused person so-and-so, wherein they admitted of being guilty in trafficking so-and-so tablets for monetary benefits. They revealed that they were carrying the tablets from Silchar, Assam to Kuch Bihar, West Bengal. They admitted that the supplier of the seized contraband was Shehnaz Iqbal Laskar of Kachar, Assam, and Raju Hussain of Kuch Bihar, West Bengal, and receiver was Ansrul of Kuch Bihar, West Bengal. On 23/7/2025, voluntary statement so-and-so was recorded of independent witnesses, Muhammad Ahmed Ali, Constable, Railway Protection Force, and Rama Shankar, Constable, Railway Protection Force, Gauhati Railway Station, Gauhati, wherein they admitted that they had witnessed the procedure and search and seizure of the seized so, thereby testified the seizure. Paragraph 25. That dated 12/7/25, based on voluntary statement and prima facie evidence, suspected persons, namely so and so, were arrested by Rahul Kumar. Now, their statements were recorded. They were produced before the officer. The concerned officer was Rahul Kumar, and thereafter they were arrested for violation under section 8C22C. Grounds of arrest under section 47 BNSS was explained. Intimation of arrest to their relatives and concerned police station was with a request to provide any pass so and so. Now, Lordship will see when they were arrested. Now, this process, we cannot go and simply suspect somebody, this person is carrying some, we cannot simply go and grab him, you are arrested. We have to be sure whether the materials are there with him. Only then. Now, the whole process culminated in the arrest, and it took some time. And the arrest was on 12/7. And now I'll take your Lordship to the concerned paragraph. At paragraph 29, page 76. That on 13/7/25, being holiday, Sunday, the Honorable Judge so-and-so, White Court order, perused the papers relating to the arrested persons, namely so-and-so, along with seized contraband and their Jama Talashi items, and allowed them to forward to judicial custody. Further, regarding drawing of, that is all right, Lordship. Now, they were arrested on 12th, and they were produced before the learned magistrate on 13th. In my humble submission, Lordship, there has been no violation of any law laid down by the Honorable Supreme Court or by the statute. Because Lordship will appreciate getting an information that somebody is carrying contraband. I cannot simply go and arrest somebody on that count. It has to be, the contraband has to be there, or the information has to be there. Now, after the statements were recorded, there was a prima facie finding that they were interrelated and there was some kind of mischief that they were in. Therefore, my submission would be there is no violation of any law, Lordship. And so far as Lordship, the notices, time is not there, yes. But Lordship can very well appreciate 10:55, they got up on the train, 11 trains started moving. Then there was another car also moving simultaneously. Then they were brought back to Gauhati. Their statements were recorded. Only after that, and that would definitely consume some time. And in so far as Lordship, the notices under Lordship section 47 and 48, I leave it to your Lordship, but would your Lordship again review your Lordship's decision, because Lordship has given a finding in the earlier judgment. Rightly or wrongly, Lordship. That I leave it to your Lordship. But the materials are there, and if your Lordship will see the grounds of arrest, that is annexed at page 35 of the petition. I'm referring to only one of the appellant's petitioner's lordship. It's all the same. Now, it is there in detail. I cannot, as a police officer, write a bail petition for you. I can give you only the details. You will have to do the rest. And insofar as information to his relatives is concerned, lordship, I see lordship there, it has been served to his brother. And once these questions have already been gone into by your lordship, then I leave it to your lordship. But so far as the other ground is concerned, lordship, I think I have been able to make out a case, lordship, that the arrest was made on 12th and they were produced before the learned magistrate on 13th, lordship. May I submit? May I submit, my lord? Most important thing is that, my lord, I use the word detain. And your lordship kindly go to the Constitution of India, my lord. Lordship, kindly read to the Constitution of India. Every person who is arrested and detained in custody shall be produced before the magistrate within 24 hours of such arrest, excluding time necessary journey. And I was detained on, my lord, my humble submission on 21/7 to 11/7/2023. One document I shall produce for your lordship. Lordship. Yes. 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 That is what lordship, if my learned friend wants to interpret detention, like lordship, that can be any kind of detention, lordship. May I submit, my lord? Why, my lord? Detention means you are confined him to something. Yes, my lord, that is why I am submitting before this. Yes, ma'am. That is what. That will not, no, here, if I may just, if. That is what. Now, if I may just try to distinguish, now, lordship will just take an example. I'm a police officer. I'm a police officer. Lordship will just bear with me. I call a person, I suspect him for doing some foul play. I call a person to the police station. I kept him in the police station, not allowed him to move. Like lordship knows, the whole day wasted. That can be termed as a detention. Now here is a moving train. I have to get him down. I have to bring him before an officer. Well, no, my lord, may I argue, my lord? Either way, your lordship kindly allow me, my lord. Because, my lord, why this law has come, my lord? Because there is a reason behind it. A people has been taken, keeping in police station 24 hours, more than that, and he was subsequently arrested and produced before the police. That was not. Basically, a person has been arrested, warrant case, warrant has been there, my lord, and cognizance has been given. That is why legislation, if we give all the power to the police, because NCP is also police officer, my lord. Then, my lord, if you give all the power to the police, then I have to give some constitutional safeguard, my lord. That has been started from Modulimai and other cases, my lord. That is why the word has been used, detained. And I have produced two judgments, my lord. Yes, my lord. My lord, detained. Because these two, Well, that can be termed as a detention. But here I have to bring in lordship if I have to make out a case. My humble submission before your lordship is that these two judgments, your lordship kindly minutely look. These two judgment has categorically stated he was taken and he was produced after 2 days, my lord. Yes, my lord. That is important, pen. Yes, my lord. Yes, my lord. 10:55, the officers went there after lordship, they identified that person, gave him the notice under 67 and asked him to appear. He has to be brought back. My lord, he was asked to appear does not mean he was in custody from, my lord, 11/7, detained. Let him say, produce the case there is so. I was kept scot-free. Detained mean he is taken the custody, my lord. And one thing I saw important thing, my lord. Page 29, my lord. Lordship, page 30 of my petition. Important thing is that, man. Last part. At that, my lord, the inspector so and so identify Arman Hussain, Arif Ali, and serve saying notice to them around 10:55 p.m. I was at that time down their detention. Page 30, last part. Pankaj Kumar Chauhan, so and so serve notice. At 10, Pankaj Kumar Chauhan, Inspector Sanjit Kumar, Inspector Sipoy, Kanchanjunga Express, whereas Rupesh Kumar, driver, was instructed to proceed official vehicle be in touch and civil Kanchanjunga Express. The said left. I was detained on that time, my lord. And perhaps my friend is misconstruing. Lordship can have a look. Perhaps my friend is misconstruing the. My lord, he was detained in that place. Whether he was allowed to go scot-free, my lord. If they were allowed to go scot-free, then I'll defend. They are detained on that period, my lord. My humble submission. And all these judgments squarely covered by both two judgments, my lord. Another important thing is that, my lord, he has said, my lord, 48, your lordship cannot look. If some point is not argued before the Lord, I am asking when the 48 notice was served. Admittedly, they have stated it was served on the court premises. They said, and there is no ground of evidence. In their, to that effect, my lord, I want to read page 77, para 29 of the, my lord. Dear, my lord, final complaint, my lord. On 13/7, Sunday, holiday, peruse the paper relating arrested menu, Tahir Hussain, Arma Ari, along with seized contraband, Jamaat Alasi followed them to forward judicial custody. Further, regarding drawing sample honorable in compliance of the order, arrested, namely Tahir Hussain, were forwarded to judicial custody. Intimation to kota sile to. Yes. Intimation. Yes, my lord. Page 75, my lord. Sorry. Para 25. I'm extremely sorry. The 12/7 voluntary statement prima facie evidence accused person Tahir Hussain, Laskar, Arman Hussain, Arif Ali were arrested. A ground of arrest 47 was explained to the intimation arrest to their relative and concerned politician with request to provide past criminal were given. 48, a telephonically intimated their relative respective arrested. Their stand is that we are only telephonically arrested. And if your lordship go to their, my lord, record, my lord, 48 notice, your lordship will not found some brother of the accused person. Subsequently, I found it is my duty to produce before the court to show, my lord, that it was served to the brother I have given. And I am, my lord, Pankaj Bansal, paragraph 43, why I am said the reason behind it, my lord. Yes, my lord. Pankaj Bansal, I have given, my lord. अरे सारा दिया ना आसान किया बेस 43 आसान नहीं मुतन में आसान Lordship kindly look to this. The second reason why this would be proper course of adopt constitutional object underlying information given. Conveyance of this information is not only to apprise the accused person if she is being arrested, but also to enable such person legal counsel thereafter in presence of the case. In this regard, as Santhil Balaji placed on record, we find that same run into 6 pages. The ground of arrest recorded in the case on hand relation Pankaj Bansal Boson have not been produced before this court, but it was contained that they were produced at the time of remand. That is important, my lord. However, as already noted earlier, it did not serve the intended purposes, my lord. Have a look got it, my lord. Then, my lord, I am leaving further their ground, Pankaj Bansal. Then, my lord, last part, more so a person who just has been arrested would not be calm and collected favor and may be utterly incapable remembering the content of ground of arrest. Read by or read out her, the very purpose is constitutional security protection would be recorded, legally permitting the concern to merely read out reading ground of arrest irrespective of the land into compliance requirement 22 amended 19(1) PMLA. If your lordship go to the final complaint, it was only intimation of arrest. This is not ground has been informed. My learned friend has argued before your lordship that whether we shall write the bail application, it is not there. If a person was arrested without warrant, you have to take all the basic facts. Your lordship's judgment also there. Sakitul Islam, my lord. Your lordship has passed because nothing has been recovered from my possession. And all the basic facts has been produced before the persons, my lord. And it was given after 2 days of the detention. Assuming 12, 13 I was given. They should give all the to the family member of the accused person, not given. 47 is also like that. That part was not argued before your lordship, my lord. That is why I am taking, my lord. I want to give some judgment, my lord, if your lordship goes to the judgment, my lord, in respect of 36, my lord. I said that this is the police officer. And police officers cannot be, my lord, respected person of the area. Para 8, my lord. Pankaj Kumar লাগবে সেটা
Pankaj Kumar.
তাই সাবমিশন তোমার লাগে ভাল লাগবে Yes, ma'am. Para 8, the learned counsel plan has submission pointed out that signature of witness available on memorandum of arrest 23-6, which was issued. The learned counsel submits that the column signature of witness, signature of A. Mustafa. The learned counsel submits the in fact of sub-inspector working in the going, I am neither family member nor a respectable member of the locality, independent person. The learned counsel submits that 36 of BNSS specifically mandate the memorandum where he must be arrested by at least one witness. Why should be family member of the person arrested, respectable person locality? Accordingly, my lord, the court said that she submit the specific mandate 30 BNS which clearly violated arresting authority. So he was released on bail following the DK Basu. Your lordship, read the DK Basu 34, 35, and 43. 34 and 35, some guideline has been given, my lord, that his one should be person from that locality if the family member relative is not available, my lord. I read the learned counsel applicant support of argument, provided it is disabled officer arresting a prepared memo of arrest at the presence of at least one or two who may be a member of family arrest and respectable one of the locality. The learned counsel submit the law laid down DK versus law headed 22-1, 21 and 20 constitution. He the same is required. Therefore, the learned counsel submit the instant memorandum that contain signature of an official NCP rather than arrested signature of member of family. Respective person locality arrested, the arrested application is violation of the constitutional right. Accordingly, my lord, he was released on bail, my lord. Then other paragraph, your lordship will look this judgment. Then another judgment important, my lord, our division bench. 40 judgment আছে. National investigation. My lord, your lordship kindly look one paragraph of Bihan Kumar, important, my lord. That I have to take my instructions. I'll not start, man. Just search it, sir. No. Yeah, yes, my lord. Para, my lord, your lordship kindly look to the para 37. It is your duty as given Tereta. Yes, my lord. Your lordship kindly come to the para has 37, my lord. The learned single judge unfortunately has equated information given regarding the arrest with the ground of arrest. The observed non-allegation of supply of gunmen made by the appellant has blunt completely uncalled for. All court, including the High Court, duty to uphold the fundamental right. Once a violation of fundamental right under Article 22 on LS, it is duty of the High Court to set contention, decide one way or other. When a violation article is searched in respect ground, there can be two contention. The arrested person not informed the ground of the purported information ground of arrest. As far first contention is clear, the person arrested discharged burden simply alleging that ground of arrest was not informed to him. If such allegation is made, pleading the entire burden on the arresting agency or to satisfy the court effective compliance was made. Requirement of Article 22(1), therefore, in view taken, the High Court view taken is completely erroneous. My humble submission before you explain my duty. There is a one judgment, my lord. I remember AN 1980 SC 1980 issued by the Sorossia. Paragraph 5, my lord. Same thing has been said, my lord. Supreme Court, my lord. Yes, my lord. It is their duty to show, my lord. Then, my lord. Yes, sir, my lord. It may also be then, my lord, paragraph 42. This benefit was given to 48 also, my lord. Yes, my lord. Then, my lord, I am relying, my lord, many times, my lord. One judgment of our division bench of the High Court, my lord. It took one second. Yes, sir. Para 23, other paragraph are important, my lord. I am not reading, my lord, for paucity of them. Perus, para 20, my lord. Have you not seen para 20? Other important paragraph is there, my lord. 17, 18, 13, 12. A perusal of two court paragraph clearly showed it was never the case appellant ground of arrest accused respondent was served on the accused respondent at any time prior to 26. As such, turn around the stand taken by the appellant is appeal, except especially when there is no date expressed the signature brother of the accused, the copy of arrest respondent. Para 11, my lord. Para 11, no record has been produced before the special court to show the ground of arrest in writing had been communicated to the family member of the accused. That is important. Para 11. ওই দিব লাগে মই পাহৰি যাওঁ আজিকালি হৈছে বয়স হৈছে DK Basu, your lordship know very well. There are 34, 35. I am giving the copy, my lord. DK Basu. 34, 35, 37. Yeah. And another, the copy to the Sarah. Sarah copy to the 34, 35, 37. My lord, real lordship. Earlier, my lord, 50A, 48, earlier 50A, my lord, page 5. The inserting section, this one, my lord, Arvind Mansur persisted. The in Bihan Kumar State of Haryana supplementary judgment, the purpose of 58 to inform the arrest person for person nominated arrested person to ensure that they would be able to take immediate prompt action to secure release. The arrested person, because of his detention, may not be immediate easy access to legal process for securing release. Friend, relative, nominated person. Therefore, the purpose of communicating the ground of arrest to the detainee, in addition to the relative message, not merely formality, but to enable detained person, have you got it? To know, provide necessary opportunity him to his relative, friend, nominated person to secure his release at earliest possible opportunity for equally fundamental right, liberty, life, Article 21 of the Constitution, and hence the requirement is not only arrested but also to the friend, relative, other person may be person. This was, my lord, recent judgment by the Appellate Court and negated the Darshan case also, my lord, and subsequently, my lord, this order has been passed.
Darshan Lordship has further clarified.
May I
So far
submit,
as-
my lord?
Yes, after he finishes.
Forum is equal, my lord. But our High Court in National Investigating Agency case has categorically stated former will follow. My lord, former will follow. This is the judgment of the division bench, my lord. And this is the law also, my lord. This has been flow from the one, my lord, insurance company case. Constitutional. Yes, yes, my lord.
Rana City.
Oh. And that is flow from that, my lord. The former will follow, that is why. Yes, my lord. Yes, my lord.
It's that perception always changes from time to time.
But my lord,
Yes,
yes, my lord, I am on my lord judgment on the basis of judgment of the apex court. I argue before the court because my lord, both way, my lord, your lordship can argue. This is my landed friend will submit. Yes, correct. I am not on that, my lord. My submission, my lord, if fundamental, my lord. Yes, my lord.
Basically, these are guidelines for all times to come.
My lord, my lord, my your lordship is correct pillar of governing of this society, my lord, to uphold the Constitution of India, my lord. That is why this guideline has been incorporated. Because, my lord, if a person is arrested without a warrant, that is why I am submitting. When warrant has been issued, that cognizance has been taken, judicial mind has been applied. Here, if your lordship give all the power to the police, I am not on tax law, my lord, then that will be, my lord, dangerous preposition for the society, my lord. Because, yes, my lord. Yes, my lord. Yes, my lord. Because, yes, my lord. Yes, ma'am. Because, yes, lordship is correct. Yes, ma'am. Yes, ma'am. Yes, ma'am. Yes, ma'am. I got how it's I have a knife now. My humble submission before your lordship, I am doing many custodial detention case, my lord. I found, my lord, generally, my lord, I found how, my lord, at that time, my lord, at the time of disturb area point, my lord, what happened? I know, my lord, what happened, my lord, because this yes, my lord. Ultimately, yes, my lord. Yes. There. Your lordship is absolutely correct. But my lord, if my lord, your lordship, not my lord, if the honorable court has diluting the fundamental right, that is also dangerous thing for the society, my lord. Now, yes, my lord. That is why the honorable Supreme Court has, my lord, so stringent about the fundamental right. Yes, sir. Yes, sir. Yes, my lord. Yeah, yeah, yes, sir. Yes, lordship is correct. Yes, my lord. Yes, lordship. Yes, my lord. Yes, my lord. Yes, my lord. Yes, my lord. That is what lordship. I have. একটু বলবো। Yes, my lord. Yes. My lord, para 8, my lord. My lord, Salatul Rahman. Further, the learned counsel for the petitioner also submitted at the time of preparation of arrest memo. After the arrest of the petitioner, the signature of independent witness. Para 8, my lord. Further, learned counsel for the petitioner also submitted at the time of prepared arrest memo. After the arrest of the signature of independent witness was not of the arrest memo was required under the law. Therefore, submit has been violation of mandatory statutory provision law and that to get the bail. Then para 13, my lord. The learned counsel NCB has submitted that at the time of arrest petitioner, the body of notice section for itself, the petitioner have acknowledged the fact his own anything. They have intimated the error through their relative, their brother-in-law over telephone. She therefore submit that has been full compliance with the recon furnishing ground of arrest relative person in this case. Next, your lordship come to the para 18, my lord. There are other paragraph also, I am not reading. As regard the question of whether the notice under section 40 have properly served relative, apart from the final comment, the NCB stated just said notice was sent to relative petitioner by the register post. Nothing could be shown on the record like postal receipt showing actual sending notice to the relative soon after the arrest. Petitioner postal track consignment to indicate notice was actually received by the person whom was sent. That was not available in the instant case. Then 1948, my lord. Map parts, my lord. Yes, my lord. I also give the Probir perhaps I am dealing. You also have the copy of Probir Purka as well. That Probir Purka has said one thing, my lord. 22.5, Article 22.5 and 22.1 is the same, Probir Purka. And it was said by the Constitution on bad judgment. Moment it was said, the whole protection of preventing detention will come. Because, my lord, in NSA cases, this has been followed. All the preventive detention law will come, my lord. And Probir Purka paragraph 38 has said that if it is within WhatsApp, that will not serve the purpose. Main thing is ground up, arrest was not communicated to the family member, my lord. Earlier it was not argued, my lord. It was intimated is something different, my lord. It was not served to the family member, my lord. If your lordship go to this, my lord, final complaint also available that, my lord. 36 was not complied with, my lord. 36, 40 and 22. That is my humble submission before lordship. Much obliged.
Lordship, I had already made my arguments. So far as the delay part is concerned, basically he's harping on that. I've made my submissions on that. But your lordship will also consider, I'm aware it's a quorum of same quorum. But your lordship will have a look at paragraph 20 of case of Darshan. 20 that it has got some sub paragraphs. It lays down lordship.
Abu Mansur, Mansur.
Lordship.
That was discussed, Ahmed Mansur also, Darshan negated. And division bench also, man. Both cases. Huh?
I fail to understand how a police is, we don't respect.
I am not saying, man. I am saying something differently. Yes, sir.
Police.
Yes, sir. Conflict of interest.
Here lordship, arrest and witnesses is the railway police, arrest by the NCP. So they don't have any